Hi, guys. It's Kathy. I hope you're doing well. So, my computer just did an exorcist thing on me, and I had to reboot real quick. Outlook just opened like 80 tabs. I don't know why. I don't use Outlook. What that means to you is we have to find what video we're at again. That's right. We are used to it. This is not going to be the last time we have lost the video that we're on. Oh, I thought I would have to scroll more. Let's do that again because it's very, very satisfying. Look at all those we did, guys. You guys are awesome. Look what you did. That's a lot of videos. All right. Purple suit. Purple suit. We still got her for a while. Purple suit. What? Wait, is she in a different outfit? Yeah. But still, it's still her. Wow. Oh, no. Now he's back on the stand. We should stop. We should stop cheating and looking what's going on ahead. Oh, no. Hey, guys. Can anybody hear me and see what's going on? I'm getting massive errors from my streaming software right now. Okay, good. I'm just... Hold on, I just got to get rid of Facebook and I have to get rid of Twitch because... I don't know, it's just erroring out right now. That means all one of us who are watching from Facebook is going to miss this one episode. They're just joking. There's 0 people watching. Trying to make myself look important by saying one person's watching. 0 people. 0 people from Twitch are watching because I found out that they don't save your streams on Twitch. So unless someone is sitting in front of their computer at 4:30 a.m. when I start, no one from Twitch is ever going to watch there because it's gone. It's already gone. My stream that I just did is already gone from Twitch. It's not there. There is a way to save it for a couple days, but not like YouTube. It just doesn't stay there forever. And I don't know why people aren't watching from YouTube. I thought OJ would be a hit, but that's okay. We're going to watch OJ. All 9 of us here right now. Oh, look. Closed caption was on. There we go.
And I've never seen a court attempt to restrict that because that is obviously a matter that a criminalist would have to determine based on what he can recover.
Mr. Shapiro?
Your Honor, according to Dr. Henry Lee, our chief criminalist who's the head of the Department of Criminology in Connecticut, he tells us 1 to 3 years are sufficient. I think perhaps this may be an appropriate matter for the court to have a hearing on. 100 years is unduly invasive. Makes the inventory of the hairs a very, very difficult task and certainly allows for the possibility of the commingling of samples, which could contaminate the test. So we would ask for a hearing on this. I've been practicing for a long time. I have never, ever heard of such a thing.
Right. This is what I'm prepared to do at this point in time, and that is to order no more than 10 hairs at this point. If the prosecution at some point feels that they...
Guess what I did? Anybody know what I did? Anybody see why we're not on the right video? I know why we're not on the right video, but did anybody else notice why we're not on the right video? I scrolled the whole way down to the video we're supposed to be on and then never clicked it. I just never clicked it.
Where she was. I indicated to you I was going to get her back here, one way or the other. And you indicated to me to call the district attorney's office, and I followed, and I called Darden and told him what's happening. So there's an honorable quality about this lady, and I hope that's shown through in her testimony. I ask the court to consider.
Whoa. There's an honorable quality in that lady? For where? How? What? At what point was she honorable in her lives? Somebody help me figure this out. Oh, no. All right. Put your waders on because it's getting pretty deep in here.
Consider. If you have any other questions, I'll be glad to try and address them.
All right. Thank you, Mr.
Thank you.
Cochran. Mr. Darden.
Now, as I sat here listening to Mr. Cochran, I wondered, are we talking about the same Rosa Lopez? There are, sorry, did you say something?
Are we talking about the same?
Mr. Cochran
Rosa
must have had a hard
Lopez?
time keeping a straight face as he argued the credibility of
I like
Rosa
Darden.
Lopez. The issue at this point isn't whether we should hold a 1335, a conditional examination. The issue is why should we hold a conditional examination? Rosa Lopez has taken the witness stand. She took the oath. She promised to tell the truth. And she did the exact opposite. She told us that she'd made reservations to leave. We called and checked. We found out that she hadn't. And when we confronted her with it, she admitted that she had lied. She told us that she was going to make reservations. I'm not sure that she has, or that she did today. She told us that she hadn't made reservations to leave at some other time. And now we find out that on February 21st, that she booked a round-trip ticket to El Salvador. And what's important about the February 21 date, Your Honor, is that 4 days before, on February 17, she signed a declaration under penalty of perjury saying she was leaving and she wasn't coming back, saying she feared for her life. You tell me what's going on here. Talking about contradictions. There are contradictions here, contradictions made under penalty of perjury. You can't believe anything Rosa Lopez says, I think, at this point.
Was it the declaration on the 17th that says that she's leaving? I thought that was one that did not say that she was leaving. Let me just double check here.
The February
I stand
17th declaration.
I stand corrected.
Okay,
I stand
that's right.
corrected. There were other declarations that did not say that.
Okay. The February 17th declaration says, I've decided to return to my native El Salvador on February 25. That's February 17. And on February 21, she makes a round trip, a reservation for a round trip ticket for March. Okay. We would certainly like to see Rosa Lopez testify in front of the jury. And if what we've seen today is a sneak preview of the defense in this case, then obviously we're looking forward to it. But Ms. Lopez makes these claims and allegations about Broncos and Detective Furman and all these other things. And they're important things, even if her account is untrue. But they're the kinds of things that a jury ought to hear, especially given the complete and total lack of credibility that Rosa Lopez has. They haven't proven that she's about to leave. What we found out about Rosa Lopez is that her accounts, her views, her positions, and her testimony changes with the wind, Your Honor. It changes with the seconds. It changes with time, and she will change and modify that testimony and her view and her position at any given moment, depending upon who is asking the questions. There is no credible evidence in this record to suggest that she is about to leave this jurisdiction. In fact, the most credible evidence in this record is that she is going to purchase a round-trip ticket in March of 1995. I would ask that the court take note of her cooperation with the defense in this case. She told Ms. Villapando that she called her attorney on many, many occasions. Even when they didn't return her call, she still called. And when she left the state, she called to tell them where she was and to tell them that she would be here. She booked a round-trip ticket for March. She'll come back. She says that she feels as if she has a duty to tell the truth and to assist this defendant. Rosa Lopez will be back. And I'll tell you, Your Honor, if you don't hold a conditional examination today, she probably won't leave the city of Los Angeles. She probably won't even visit the ticket agency. or the travel agent. There's nothing, no credible evidence, no credible testimony in this record to suggest that she is about to leave, and the motion ought to be denied. There are many, many contradictions in the record that I could speak on, in which my clerks from Southwestern Law School were careful to plot out for me so that I could argue those points to the court, but I sense that the court is aware of those contradictions. How can the court accept this witness's testimony? How can the court find her credible? How can we possibly believe that she is going to do what she says? Even as we stand before the court now and argue this issue, I suspect that in the media right now that they have uncovered other contradictions in the testimony that she has given today. The defense has failed to carry the burden, to carry the day on this issue, Your Honor, and we didn't beat up on her. We didn't treat her like they treated our witnesses. We didn't treat them like they treated Ron Shipp, and we didn't ask her about her drinking problems or other personal business. Okay? We treated her in a dignified manner. This is a court of law. Mr. Simpson's freedom is at stake. The people's right to a fair trial and the public safety is at stake. Given the information she claims to have, and given their complete failure to sustain their burden under 1335 and 1336, the court ought to deny the motion. Ms. Lopez is on her own, as she should be. I'm sure that she will return to her daughter's house. I doubt that she ever slept on the street or did any of that at all. We know where she's been, and she's probably been playing the slot machines and having a good time. And I've indicated to Mr. Cochran that if the DA's office can assist in any reasonable manner in helping them to keep their witness, or they can stay in contact with their witness, and we're happy to do that, because this is a search for the truth. And we think we know what the truth is, and we think the jury is going to find the truth at the end of this, and we want to help. We want to help the defense, but not this way. It's unfair. It's wrong.
Mr. Darden, let me ask you to address this issue. On the other side of the ledger, having noted the contradictions, the record also indicates that she was, in fact, out of the state of California until the early morning hours of today, that she voluntarily returned, which shows her good faith. And the information that I received that we stipulated to in a sidebar was she was, in fact, outside of the jurisdiction of the state of California. So don't I have to also take into consideration the fact that she did voluntarily come back? She was beyond the jurisdiction of the court. And shouldn't I take that into consideration in evaluating the truthfulness of her statement that she's going to leave? Question number one. Question number two is, do you want to roll the dice? Say, for example, I accept your argument that based upon my analysis of the credibility of the testimony of the witnesses here, that there has not been established that the witness is about to leave the state, as is required under 1337 sub 4. Let's assume that I accept that argument and deny the hearing. We go forward and she does in fact leave the jurisdiction and goes to a place where she is beyond service of the Interstate Compact on witnesses. Let's assume that the worst happens.
Okay, fine. Let's assume the worst happens. Let's assume she does that. Who cares? It doesn't matter what she says. Unfortunately, the jury did not hear any of this. So they don't know that she's just a big fat liar. We know, but it doesn't matter. But it doesn't matter what she says on the stand because she's a liar. It doesn't matter what her testimony is.
Happens as far as Mr. Simpson is concerned, and he is found guilty of some felony serious crime. Then we have an appellate issue on the abuse of discretion by this court, failing to grant a 1335, when the only downside is that if she is unavailable under we have to have a 240 hearing somewhere further down the line to see if she's still in fact unavailable at the time that the defense case goes on.
Okay, but isn't the other also possible? Even though it didn't happen, Can't there be an appellate issue if they shove her in now when it's not her turn? Because, I mean, he clearly proved that she's not leaving the country. So there is no lawful reason for the defense to put a witness on during the prosecution's turn, their case in chief. So isn't the opposite also the same?
The court should consider her return to this jurisdiction to testify today as proof positive of her willingness to assist the defense in any manner that she can. And I think that's probably about all that it's worth. And as far as rolling the dice is concerned, Your Honor, we believe that the record supports a finding that they have failed to carry their burden. The court does have discretion. There are many contradictions and inconsistencies in the testimony of Ms. Lopez and Ms. Lopez's testimony as opposed to the second witness. And this testimony, all of this testimony, we believe will support the court's finding that a conditional examination is inappropriate under these circumstances. We don't see it as an issue of rolling the dice or not. It's not a roll the dice issue. We fought hard on this issue because we believed this person to be, and I don't want to offend anyone this afternoon, but we did not believe she was a credible individual. We felt that the jury ought to hear her testify. That is, if they really want to take her testimony. That is, as opposed to creating an appellate issue in this case. At any event, Your Honor, the record, we think, fully supports the court's finding, if the court is inclined to so find that a conditional examination is not necessary. I don't think that Rosa Lopez will miss out on testifying again in these proceedings
22
in front of the whole world. I think she'll be back. I think if Mr. Jones asks her to come back, or if Mr. Simpson should ask her to come back, I think she will. I'm sure she will. I'm not sure they're going to want her to come back, but I think if they ask, that she will. And once again, the people are prepared to offer some assistance to the defense in terms of bringing her back if they really.
And the people maintain their position at this time that they will not allow, or they object to calling Rosa Lopez out of order so that she can testify in front of the jury.
I'm sorry, Ron, I didn't hear the
Do
beginning.
you maintain your position that you would object to calling her out of order?
Yes, Your Honor.
All right. Thank you, counsel.
If the prosecution is so confident that Rosa Lopez is not a credible witness, then let me reiterate our offer that we made earlier, we just asked them about. If they're so convinced, let her call her in here and ask her, Judge, if we can put her on the stand Monday morning. She can leave Monday night. Let her testify before this jury on Monday. Since they think they're so proud of what they can show, let her testify. They want to search for truth. Let them do that. They're not going to do that, Your Honor, because we'd asked them that before. And I think it's really the height of arrogance and really unfair. Mr. Darden knows that she was not in Las Vegas, Nevada. Her flight went through there. She couldn't get a through flight. That's why she flew last night till 1:30. And how disingenuous is it for a lawyer to stand up here and talk about slot machines when the only flight she could get was through Las Vegas to get to L.A.? That's preposterous.
That argument doesn't carry any weight because
it may not, but it
know
offends me because it shouldn't have happened, Your Honor. And so I have to, I feel duty bound to say that. Please allow me that. Now, having said that, let me get back to the issues. You put your finger on it directly. The prosecution, in their zest to win, their obsession to win, well, they don't care about rolling any dice. In this case, they're not worried about that. You are the judge, and you're the one who has to be wise. It's your discretion who's at stake. What we're saying to you, you saw this witness who came back on her own. She didn't have to do that. She doesn't want to testify. She didn't get anything out of this. If she doesn't come back, if she does what she says she's going to do, and I found her credible on that. She said she'd come back today. She did that. She said she's not coming back after today, and I believe that. You heard those particular questions, which were the most important ones here today, even though she had respect for you because of what it's done to her life. And, you know, for them to say that she didn't sleep on the street, that is the evidence from this case. That's what she testified about. And we know she then left this jurisdiction. And the whole evidence is she's had this problem with her family. It just seems to me to defy credulity and to be the height of insensitivity for them to talk about this. They talk about this as a witness. A witness. She's not a party.
What do you mean the height of insensitivity? This is a murder trial. She is a witness. What does sensitivity have to do with anything?
To this case, she should be treated with some amount of dignity, and I think the court is doing that and looking at all the facts in this case. When you do that, I think we've made our burden. If you look at any case where a witness has been away, came back on their own with no place to stay, and says, I'm not going to be here afterwards, and you have a man charged with the most serious of offenses, what more can we do under the circumstances than to make the presentation we've made? She's here because we made arrangements to get her back and because she called us, not because they did anything. If they really don't think she's credible, let us.
I don't even know what her testimony might even be about. She is the housekeeper of a neighbor.
Let her come before the jury. Otherwise, let us have our 1335 and let's resolve this matter and move on, Your Honor.
The Court of Appeals takes a look at this record. They'll look at the record as it stood today. And regardless of what may happen in the future, but as the record stands today, how
Rosa
can
Lopez?
you find her credible? How
hell
can
no,
you
they
possibly
didn't.
believe that
She's
she's
a
about
liar.
to leave? She has lawyers telling her, hey, it's okay. It's okay to go back to
Well, the thing that troubles me the most, Mr. Darden, is the fact that she was in fact out of the state today.
That's what Mr. Cochran has told us, yes. And she's back. People come and go all the time, Your Honor. She has come and gone from here to El Salvador, 27, somewhere between 27 and 50 occasions. We called down to El Salvador. She can't hide from the media, and from what I understand from our conversations today, they're a lot more ruthless. That is the media. That is the media is a lot more ruthless down there than they are here, as I understand. There are billboards down there saying, if you see Rosa Lopez, call this number. We learned today, Your Honor, that.
Well, Mr. Cochran, it's interesting. I'll hear it.
Sure,
I can make the distinction.
There was a Rosa Lopez sighting in San Salvador a short time ago.
I'm not surprised about that.
And they hounded and followed this woman for quite some time until they finally realized that she was not this Rosa Lopez. The reporters our office spoke to today say they are waiting. They are waiting for her to land. She's big. Maybe bigger than you, Judge. I don't know. But she can't run from the press, and none of us can. But the record still is clear. There is no credible evidence in the record, no credible proof that she is about to leave. Can't believe anything she says. She contradicts herself. I mean, there are inherent conflicts in her own testimony, Your Honor. And you don't have to beat up on her or badger her to bring these conflicts out. She conflicts herself. What else can we do? We have a right to a fair trial.
It is a contradictory record. You are absolutely right.
And so, under the circumstances, the court certainly has discretion given these circumstances. And we don't see it as an issue of rolling the dice. We're in it for the long haul. And we think that the court, that should the court deny this motion, that the court will be standing on sound legal grounds.
All right. Thank you, counsel.
Last thing I'd like to say, Your Honor, is we don't see this as anything funny at all. The fact that there may be press or he made some call down to El Salvador and sending messages like that, I think are very, very unfortunate. If everybody around the world is watching this, how we conduct ourselves seems to be important. And what I'm concerned about is this particular witness. This lady believes her life is in jeopardy. What we do has a lot to do with that. And it seems to me
counsel, the issue goes back to 1337 sub 4, correct?
Yes, Your Honor.
That's the issue.
Yes.
All right. Thank you.
Judge getting all legal on them when they're badgering each other.
Well, this is an interesting situation. This is an abuse of discretion standard that I have to apply here in finding whether or not a conditional examination is necessary or required under these circumstances. We have a witness who on the positive side of the ledger was in fact, and I believe was in fact out of the state of California until the early morning hours this morning, was in fact out of the state.
I don't believe that.
She did in fact return and cooperatively after the request by her attorney, Mr. Jones, and by the defense counsel here. She has stated unequivocally to the court today that she intends on leaving tomorrow. On the other side of the ledger, we have the fact that the reason that she has given the press harassment is contradicted by her cooperation with KMEX Channel 34, speaking to their reporter, Villapando, and her friendliness with the court TV personnel. It seems to contradict her fear of harassment by the press. Also, she has indicated in her declaration dated on the 17th of February that she is leaving on the 25th, when in fact she had reservations for mid-March to return on a round-trip ticket as well. So the issue is whether or not her claim, the court deems credible her claim that she is going to leave the jurisdiction and not return any time during the course of this trial, and will not voluntarily return. And in fact, she is going to go to a jurisdiction where securing her attendance here in California will be difficult, if not legally impossible. I have to balance also the materiality of the proffered testimony, which is that she observed, my understanding from the allegations is that she observed Mr. Simpson's Bronco parked at his residence at a time that is inconsistent with the prosecution theory of the case. Balancing the materiality of that proffered testimony with the factors that I've discussed here, the cautious resolution of this is to grant the motion for a 1335.
Thank you.
We'll take a 10-minute recess and then we'll commence the hearing. Conduct this.
It's not a matter of it's not possible. Yes, Mr. Darden will be able to conduct this, Your Honor, but this is an important witness, and it is important that I be here. We collaborate, Mr. Darden and I, on everything, whether I'm presenting the witness or he is. And I'm sure the court has already seen evidence of that. And I had no idea the court was going to order the jury in for tonight. There was no way of knowing that you were going to do that. I mean, you didn't even tell us. This was just, the last minute thing, given the problems.
As soon as I decided that the option of conducting a 1335 that's videotaped and taking a witness out of order in front of the jury of those two options I like taking the witness out of order much better than videotaping them.
And obviously, the court has discretion to do that. I'm not arguing with the court's authority to do that, but Your Honor, I guess I can't be here. And if the court had informed me.
Ms. Clark, I'm sorry. I apologize to you. I had forgotten that problem.
Good night.
And that's my fault for having forgotten about that. What is your time pressure at the immediate moment?
At the immediate moment, I have to leave. I won't be able to get back until 8:30 or 9.
This evening?
Right. I can come in tomorrow.
All right. Mr. Jones, would you ask Ms. Lopez to join us, please? Ms. Whites?
I wonder why she can't. I know that they're not going to ask her. We're not going to find out, but why can't she be there?
Sure. Mr. Cochran?
I am sensitive to the childcare needs of our counsel, Ms. Clark, Your Honor.
Childcare.
But the court has made your decision. That's why we have a number of lawyers on each team. There'll be various parts of this case where lawyers will not be present. This is Mr. Darden's witness. I can understand this argument. It'd be more compelling if this was not Mr. Darden's witness. But as the court has seen, Mr. Darden is absolutely capable of conducting this examination.
I
He has
agree.
Ms. Sherry Lewis. He has Mr.
She does not
Yockelson.
need to be here.
He has any number of other DAs upstairs who can assist. It's with everything else, and I want to be sensitive about this, is a balancing process. We have a lady who does not want to come back and, of course, made a finding after today, and it's a difficult problem. You can make your query, but I'd like at least to be heard in this regard. I think that Ms. Clark can be here for the parts that she can or come back, but I think you made the decision. We should move ahead. If we're going to have 20 jurors coming and all the rest of us, in this situation, when this is Mr. Darden's witness, it seems to me we should be able to proceed ahead. This is an extraordinary situation, and I think you made the right decision, and I think that we should go forward. And when Ms. Clark can rejoin us, then so be it. But this is Darden's witness.
Well, the difficulty, though, Mr. Cochran, is that Ms. Clark has been and continues to be the lead prosecutor. And given your role in this case, were you to be absent for a part or be required to be away, I would call a recess for you as well. And we made adjustments for Ms. Clark's child care requirements, and that's something the court is more than willing to do. And I just plain forgot.
I start off by saying I'm sensitive to that, but as the court heard earlier, we did. No, I am. But Darden still is going to do the witnesses. There is direct examination before Darden gets a chance. Mr. Darden. I was just trying to, if I could have just a second.
Sure.
Supposed to be one of their most critical witnesses, Your Honor, certainly.
Well, I'm told the jurors are here. Okay. See, I've really been hiding them somewhere in the
In the
courthouse.
building, I think. You're going to inquire, Ms. Lopez. I'll have something more to say after that.
Yes, Mr. Jones.
Yes, Your Honor.
Good evening, sir. And Madam Interpreter, would you interpret the court's comments for Ms. Lopez? Mr. Jones, I have made a finding that your client is a material witness. And it was my intention, in fact, I have ordered the jury brought over because I was going to exercise the court's discretion, alter the order of proof, allow the defense to call Ms. Lopez as a witness out of order and testify in front of the jury. And I have been told that the jury is, half of it's probably here at this point. And Deputy Browning confirms that. I had completely forgotten about Ms. Clark's child care obligations, and I have deep admiration for her as a single parent and understanding the obligations of a 3-year-old and a 5-year-old. And it's something that's beyond my control at this point. And she is the lead prosecutor, and she's entitled to be here when we examine this witness before the jury. Having made a finding that and it was my intention to start right now with the jury and go until we finish. And the jurors had not been in session today, so they would have been fresh, and we could have gone till midnight. And my staff is ready to stay till midnight. But I have to drive half the staff home tonight because they're missing trains. So we plan to do this. Unfortunately, and that's having made the finding that your client is likely to leave, I'm now in a position that, having determined that she's a material witness, having taken as credible her testimony that she is going to leave, I'm in a situation where I have to either impose a material witness bond on her under 1332 or incarcerate her if I cannot get her to promise me that she'll obey my court order to return on Monday. So we're sort of in a dilemma at this point. Would you take a moment? I know you've talked to your client about it already, but we're in a slightly different, significantly different situation at this point.
I understand, and I will take the time. However, we have discussed it at length. I've discussed with her the various alternatives, and I've even, in anticipation of the people's, and I assume it's the people's request that some bond be set. But we talked about that as well. She does not want to be locked up.
And believe me, Mr. Jones, the last thing in the world I want to do is do that.
Your Honor, what I would ask is permission of the court to let Mrs. Lopez address you. I simply cannot do it with the emotions that she expresses to me. She's very upset.
I understand.
May
And
she address?
I want to allow her, I have accepted her testimony to me that she is going to leave. I have accepted that as true. And I've also accepted that she is a material witness and should testify before the jury. And the jury is available. I have a logistical problem that one of the lawyers cannot be here, who is entitled and should be here, Ms. Lopez. And Ms. Lopez, I apologize to you, but I've made the finding that I believe that you are going to return to El Salvador.
Did she address the court?
Certainly.
Please? I also am sympathetic to the child care problems of a single parent. However, I would indicate to the court that consistently it has been Mr. Darden who has contacted me with respect to, or messages on his behalf indicating he is the one who wants to interview her. And we are at this late hour, in my opinion, simply because Mr. Darden has wasted the afternoon with questions that I think have to do with my attorney fees and my fee arrangements. And we set this on a Friday. There's no guarantee that we can get out of here at 4 o'clock. And I just think if we have to balance the equities here, on the one hand, having Mr. Darden, who wanted to interview her, who took the afternoon, who requested the Friday setting, against Mrs. Lopez being locked up, I think the equities fall on her side.
Well, she doesn't have to be locked up, but she'll promise me she'll come back on Monday.
May she address the
And
court?
I'll make arrangements to have her housed over the weekend. Ms. Lopez, do you have something you wish to say? Good evening.
That I wanted to leave. I don't want to be here any longer.
Todos los reporteros me han destrozado mi vida.
All these reporters have destroyed my life.
Ya no puedo salir a ninguna parte. Tengo tanto temor para tantas cosas y yo no
I
sé qué
can't go
hacer.
out anywhere. I am so afraid of so many things. I don't know what else to say.
Y yo prometí venir ahora porque dijeron que ahora terminaba esto y yo me podía ir al tomar que terminar esto, me podía
I
ir.
promised to come today because I was promised that this was going to finish today and then I could go to El Salvador.
All right, Ms. Lopez, unfortunately, it does not look like we are going to finish today. And I have the feeling, unfortunately, that your situation will not likely improve when you return to El Salvador. But I have to balance the fact that you are an important witness for Mr. Simpson and that the prosecution is entitled to ask you questions in front of the jury.
Yo le agradezco mucho a
I am very
usted
grateful to you
y también a los señores jurados
and also to the jury
que estén tan tarde por mi culpa.
that they're here so late because of my fault.
Pero yo deseaba con toda mi alma irme mañana para mi país.
But I wish with my heart that I could go tomorrow back to my country.
Ms. Lopez,
Señora
the
Lopez.
planes fly, as you know, to El Salvador on a regular basis. I will start your case, your testimony in front of the jury. The first thing we do with the jury Monday at 9 o'clock.
I will do it for you, Your Honor.
All right, you promise me that you'll obey my order to return?
Sí.
Yes.
May I make one suggestion?
Sure.
Sí.
Since I cheated at the beginning of this video, we know she does come back.
May I make one
Su
suggestion?
señoría, ¿puedo sugerir una cosa?
Yes.
Just before, I did check, maybe it relates to Ms. Clark, if you just 1 second, if you can. Would the court consider, I think Ms. Clark mentioned this earlier, would the court consider having made your finding an unusual Saturday morning session where we can try to conclude this? Ms. Clark can do it, we can all do it, and it would still allow Ms. Lopez to make that 11 o'clock flight tomorrow night. And would the court consider that? I think everybody could do it. It would get us back on track for Monday morning. We're on our new schedule Monday. And it seems to, if the court has made this finding, it better balances what you were talking about. It gives her a chance to leave tomorrow night, and we could finish this thing in one day. The jurors will be here anyway tomorrow, and I think Ms. Clark can do it. That seems to be fair.
We've scheduled other things for the jurors tomorrow.
No, that's not the answer.
Well, no, frankly, counsel, we need to have a weekend in between. Monday morning, 9 o'clock. The other matter that we scheduled 9 o'clock, we'll put off to another day. Madam, Mr. Robinson, would you contact Deputy Downs and tell him Tuesday?
That's fine. Your Honor, you recall she has no place to stay. May we approach?
Yes, we'll make arrangements for that. All right, Mrs. Lopez, just so we're clear, I'm going to order you to return Monday morning at 9 o'clock. I'll make arrangements for your housing between now and Monday. Do you understand that?
Y no quiero reporteros en el hotel donde me deje Johnny. Yo no
And
quiero
I don't want
reporteros.
any reporters at the hotel where Johnny takes me to. I don't want any reporters.
I'll do my best to assure that.
Así hago lo best for you.
I'll do my best for you.
All right, thank you very much, Ms. Lopez. Why
Thank
don't
you.
you have a seat, and we'll talk with you and your attorney in a moment. All right, then if there's nothing else to put on the record, Tell them something. All right, thank you, counsel. What do you suggest I do with our jurors since I have them all in the back room now? Tell them something? Thank them? Actually, I think I will because they've been.
They're going to notice Ms. Clark's absence, Your Honor. I don't think that's.
Well, that's.
I don't think that's.
We've
Blame something on her implicitly, wondering why they're here and then they leave.
No.
Please bring him out of state.
No, I'm gonna tell them that we had an unusual situation. There was a possibility we were going to call a witness out of order. We had some difficulty in doing that. Sorry for the inconvenience. We'll see him Monday. All right, let's have the jurors, please. Our jury. Ladies and gentlemen, let me first of all welcome you back to court. As you can see, it's rather late on a Friday and we're still working. We've been in session all day today, and I made a decision about an hour ago that there was an unusual situation where I was going to call a witness out of order and present that witness to you this evening. After I made that decision, another problem came up that indicated that we could not go forward with that testimony this evening. I was planning on going till midnight tonight with this witness if necessary because of the situation that arose. Things have changed and suddenly we're not going to do that. But that's why you were brought over and that was my intention. So I apologize to you for embarrassing you like this and bringing you over because now something's changed and now we're going to quit and start again fresh Monday morning at 9 o'clock.
Sorry, Chinny, I'm having
But
issues.
I thought I should at least tell you why you were rousted out from your location, brought over here, and told that we were going to proceed. I didn't mean to embarrass you.
Should have watched
I
yesterday.
appreciate your good humor with all of this and bearing with us. This is going to be an unusual trial, and things like this are going to happen, I'm sure, again. I see some nods. You know that this is not easy for all of us. I know that you're all impressed to see all of us here still working at 10 minutes after 6 on a Friday. But from the smiles I can see, I haven't antagonized too many of you. All right, so we'll see you again. Remember my admonitions to you, though. Don't discuss the case amongst yourselves on any opinions about the case. Don't conduct any deliberations till the matter has been submitted to you, and do not allow anybody to communicate with you regarding the case. There are some other things that I'll need to talk to you about on Monday, but I'll see you Monday. All right, have a nice weekend. All right, we're in recess, 9 o'clock.
Don't worry, guys. I fixed my issues. I just had a whole bunch of issues. Everything just broke down. Woo-hoo. You feel terrible for Rosa Lopez? Yep, you're outnumbered. I fixed my
All right,
issues.
back on the record in the Simpson matter. Mr. Simpson is again present before the court with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Douglas, Mr. Bailey. People represented by Ms. Clark, Mr. Darden, Ms. Lewis. Jury is not present. Counsel, anything else we need to take up before we invite the jurors to join us?
Pineapple.
All right.
Mm-mm.
Ms. Clark.
You guys, the court in chambers, we had filed a motion this morning requesting that this matter be conducted as a conditional examination on videotape, and we are prepared with the means by which to do so. The reason that we have made this motion, we have not been afforded an opportunity to be heard on whether this would be a conditional examination or in the presence of the jury. And we acknowledge the court's discretion in this matter. Nevertheless, we feel that it would be,
No, I thought we had this discussion
How did you know I pick my breakfast based on what you like and don't like?
several times Friday.
no, we did not. We asked for time to consider the option, although our position had been previously consistent that we wanted a conditional examination. We did not want to take the witness out of order in the middle of our case in chief. At the 11th hour yesterday, the court
It's fruit salad, banana, pineapple, strawberry, cantaloupe.
asked us again to reconsider, and we stated that we would consider, but we were never given the option of arguing to the court what our position would be. We considered the matter and determined that we did not want to proceed in the presence of the jury, but we were not afforded an opportunity to be heard in that regard. We were not. We have
No,
Okay.
we discussed this a half dozen times, Counsel.
We discussed it at sidebar at the last opportunity. The court inquired of us, I believe, on Friday, whether the people continued to object to her being called, in our case in chief, out of order and in the presence of the jury. And we said, yes, we continue to object. Then we went to sidebar at the end of the day, and the court asked whether or not we wanted to
Scrambled eggs.
have it. The court indicated that whether we wanted to consider having her in the presence of the jury. And we said we were considering that other option. But we have not had an opportunity to present to the court our position on this since that time. And I would like an opportunity to do so. I think that the people's right to a fair trial is substantially endangered by this procedure. Number one, by allowing the witness to be called out of order in the context of the middle of the people's case in chief. This highlights the witness's testimony, affords her undue importance, highlighting her above all other witnesses, which is unfair to the people's case. But beyond that, Your Honor, it's very disruptive. The people will then have to present rebuttal testimony, which is only in its embryonic stages and being formulated. There's a great deal of impeachment against this witness, a great deal, Your Honor. We've been investigating her all along. It's not that we waited till the 11th hour to do so. However, we were always of the belief, and it was a well-founded one, that the ultimate rebuttal would not occur until rebuttal in the people's in the ordinary course of things. That is, that her testimony would be presented in the course of the defense case, and that we would be afforded the opportunity to present rebuttal of her testimony after that, when the people's rebuttal began. So there was at least a 2 to 3 month window in which to further develop all the leads. Even this weekend, we've been obtaining substantially new information. To preclude us from getting all of that information and to require us to basically prepare for cross-examination in one weekend and then cross-examine this witness that the defense contends is a key witness for them, on which their whole case hinges, is basically to deprive the people of the opportunity to have an effective right of cross-examination and confrontation. It not only does it rip the fabric of the people's case at a critical point in time, but it also prevents the people from conducting the thorough kind of investigation that we're entitled to conduct with respect to this witness's credibility, which the court is already aware is substantially in question. We ask only that the people's right to a fair trial be preserved by affording the defense the conditional examination that they initially requested. Although the people's position has not changed, that the granting of the conditional examination was not required based on the testimony given, that perhaps the 1332 of the Penal Code material witness section would have been appropriate to protect their right to have that witness present. The court
To incarcerate a witness for 2 months?
No, the witness can post bond. The defense has been giving this witness money, feeding her, clothing her, housing her, paid for round trip tickets for her. I'm sure they would post bond for her as well. No, she need not be incarcerated. Court's aware of that. Court's also aware of the defense funds and the defense ability to make sure that she can post the bond. That option is available and the people urged the court to take it. Nevertheless, the court ruled that a conditional exam would be afforded to the defense for this witness. All the people are asking now is that the court hold to that ruling and conduct this as a conditional examination, so that the people will have the ability to present their case in an orderly fashion, complete the investigation that they've only been given a weekend to speed up.
I thought you said that the prosecution's been long aware of this witness.
The prosecution was aware of this witness and was conducting investigation into this witness. Nevertheless, her lack of credibility was so apparent that we could never have anticipated the defense would hinge their whole case on her. Moreover, the defense has made representations concerning subsequent statements by this witness that we were never made aware of, and to this date have no written statement on. We have only counsel's representations in the opening statement as to many of the things she's going to testify to. And I'm sure we're going to hear another version on the witness stand today, whether that be by conditional examination or in front of the jury. But the people's right to a fair trial is in jeopardy here. And I think that there's no detriment suffered by the defense if we present the conditional examination and videotape it. Don't forget, Your Honor, that they will still have her present and available to testify in their case if they want to put her on the witness stand. They will have the option. If they decide that they don't like this witness, they can put it on through videotape or not play the tape at all. If they like this witness and they see that she does a good dress rehearsal, they will have her present for their defense case. And I think that no one should be in any doubt about that. She'll be here. Nevertheless, if we do present the conditional this is a conditional examination and videotape it, the rights of all sides will be fully preserved. But to rip the people's case and to basically stop the examination and interject a defense witness that will require lengthy cross-examination and lengthy rebuttal pertaining to facts that have not yet been presented even in the people's case will be confusing and misleading to the jury, will curtail the people's right to an effective cross-examination, and will curtail the people's ability to effectively investigate her. And I'm asking the court, in the interest of justice, to allow this as a conditional examination that will protect everyone's rights.
How do you propose to prepare under Evidence Code Section 770, if you haven't already?
I'm sorry?
Well, if you're going to confront her with inconsistent statements, don't you have to do that now during the conditional examination? Are you prepared to do that?
Yes, and I think that, first of all, we can do that by being given broad latitude in cross-examination, which I'm sure the court would afford us, given the unusual nature of these proceedings and the fact that it is a conditional examination. And we can ask those kind of broad, far-reaching questions on cross-examination that will subsume the issues, many of the issues of prior inconsistent statements.
Mr. Cochran?
I thought I would not be amazed anymore, but it's amazing that the court will recall at the end of the day, yesterday on Friday, Mr. Darden was saying how he looked forward to having Ms. Lopez before this jury. In fact, he made this statement: I wonder who's going to clean up the blood after I finish the cross-examination. And I welcomed him. I said, well, you go do what you do. We have a truthful witness here. This was litigated, and as always, the people, you know, it's beyond disingenuous for somebody to come into this court at 6:30 after you brought all these jurors over here. We're ready to proceed, and the witness makes a promise to you she'll come back, and they say, well, we can't do it tonight, Judge, because I got to pick up my children, and the court is sensitive to that. And this was a ploy for them to go and try to cry and moan over the weekend and come up with some other document. For Ms. Clark to stand up here and talk about the defense doing this, she doesn't know anything about the defense. If she thinks that our whole case hinges on this witness, then she, like so many people who write about this case, don't know what they're talking about. They're not even part of this case. We have a number of witnesses, all of which they know about. So it's preposterous to say that. This is a witness, Your Honor, who's going to be leaving. The court has ruled on this matter. We all come back to court prepared to do this. They're prepared to put it over just till today to proceed. And then all of a sudden we get this motion where all of a sudden they're being prejudiced or whatever. It's the usual thing, Your Honor. And for her to say that our whole case hinges upon this witness is preposterous. We have a number of other witnesses, and they are very much aware of it. And specifically, the court has ruled on this. They agreed to it. We talked about it, as you said, a half dozen times. And when we asked for the delay on Friday night, look at the transcript. They didn't say we don't want to have her testify before the jury. They said we just can't do it tonight because even though Mr. Darden is going to be conducting the examination, Ms. Clark has to be here to see and advise him and tell him what questions to ask. And that was why we put it over. We went through this in detail. And so clearly, Your Honor, this is another attempt by them to avoid facing up to what they have to face up to in this case. And we're ready to proceed. And we should proceed. The court's ruled on this. It's the honorable and fair thing to do. And all the rest of it is wild speculation on their part and totally disingenuous. I'd ask the court to allow us to proceed at this point.
I'm offended as a woman, as a single parent, and as a prosecutor and an officer of the court to hear an argument posed by counsel like that, Mr. Cochran, today.
I agree.
Some of us have child care issues, and they are serious, and they are paramount. Obviously, Mr. Cochran cannot understand that. but he should not come before this court and impugn the integrity of someone who does have those considerations.
Marcia Love, you have no idea how hard it is for me not to freaking, my swear words are coming furiously and fastly into my head, but I'm not going to say it. I'm not going to say it to him.
And I'm deeply offended. The people, I would like to indicate the people are strenuous and vigorous in their desire to have this witness testify. We want the ability to fully and effectively cross-examine her. We feel that it would be the fairest thing for both sides to do that in a conditional examination. What the court nor the people could not know on Friday is that new information would be obtained over the weekend, which it has been, that will provide fertile ground for a more effective cross-examination. This information needs to be followed up. It will also afford us the opportunity to present our rebuttal effectively, having gathered all of that information at one time. If we have to present this witness before the jury now, we will be required to present some rebuttal now and then some later in a disjointed fashion. The people have to be able to try their own case, as does the defense. And the order of witnesses is a very important matter that we know the court is aware of. The ability to structure a trial strategy that most effectively conveys the nature of the case and the information that is required to be conveyed to the jury is a very, very important matter. It's not one to be taken lightly. This is why the defense is so desirous of having this witness taken out of order. Even if she doesn't come across effectively, the jury is adequately confused so that her testimony, even though may not be believed, will simply rent the people's case sufficiently to cause confusion and distortion of the people's case. All we want is for the ability to effectively and cohesively present our case to the jury. The defense has already persuaded the court to effect the order of witnesses that the people had proposed on the domestic violence issues. The defense now seeks to do it again, but without good cause, Your Honor. The people submit that there are substantial issues of fairness of this trial, the people's effective ability to cross-examine and to present the case to this jury that we are being deprived of by having this witness taken out of order. We do feel that everyone's right will be adequately protected by a conditional examination, but please bear in mind, Your Honor, that our investigation of this witness is actively ongoing, has been, but certainly went into high gear over this weekend, and a number of new matters were brought to light. So we would ask that the court take the witness's testimony today, but allow us to do that as a conditional examination. At the appropriate time, if the defense desires to play the tape, they'll have the option of doing so, providing they can show due diligence. But I suspect that the witness will be available to be testifying in person at that time. Either way, it's a no-lose really for the defense, but at least it affords the people the opportunity to present a cohesive case and to effectively investigate and cross-examine this witness.
What's your time estimate, Ms. Clark, for the presentation of the remainder of your case? Realistically now, would you say perhaps the end of March?
And based on what we've seen, the way testimony is going, I have a better feel for the pace. But I need to talk to the people who'll be presenting the blood evidence and the DNA evidence to really give a good idea. So I'm going to give it my best shot, Your Honor. I think that's probably fair, the end of March. I think so. You know, I mean, if you really want me to get more specific and more accurate.
Just sort of a ballpark guess in asking you how much disruption this is, just to put this in context.
We haven't even gotten to, let me help with that. We haven't even gotten to the testimony of the witnesses that make Rosa Lopez relevant. We haven't even gotten that far. We haven't gotten the testimony of Cato. We haven't gotten the testimony of Alan Park. These are the key witnesses that make Rosa Lopez's testimony intelligible. So we are going to wind up rebutting testimony that has not even been, essentially they're putting on their rebuttal before we put on anything directly to make that intelligible to the jury.
All right. Thank you, counsel. Well, certainly make my life interesting every day. appreciate the fact that both sides anticipated going forward with her testimony before the jury today. The original defense request was for a 1335 conditional examination, which I granted. And after our discussions, I was under the impression that both sides agreed that it would be better under all circumstances than to have Ms. Lopez testify before the jury, since that is the ideal situation. However, the rights of both sides will be protected under the 1335 procedure, so I will modify my order and we'll proceed. Yes, briefly.
I'm not going to respond to the last thing the counsel said, but Your Honor, both sides did in fact agree. And the fact that the people have now come in and changed that is, I think it's just outrageous, Your Honor. We can never have any closure in this case on anything because they changed their strategy. They changed their mind from day to day, Your Honor. And it seems to me that this would be.
You
not ruling,
did
counsel.
this.
Just did, Mr.
Okay. Well, Your Honor, you had ruled also on Friday night. So they're back up here talking. So I think I should be permitted to at least indicate this.
Well, no, Ms. Clark is correct in that after I made the decision, I told her if she said she wanted to be heard, and then the other issue came up with childcare. And then that sort of closed the whole issue for the evening as far as I was concerned. And frankly, since we had been in session 6 hours beyond our anticipated closing time on Friday, I was ready to call it a night then.
Never mind the court. What happened was Ms. Clark was now gone at this point. The court, we called the jury then at the end of the day and said we'd be calling a witness out of order to testify. And this was a decision. Right. It was a made decision.
You're right.
Everybody in America is looking in is aware of this was a made decision. And then they come up with this motion that nobody knew about. Darden had agreed to it. And John, I think that's totally unfair. It was unfair that they would do this.
I agree with you in many respects. However, you asked for initially a 1335. So you won the day. You got your 1335. Ms. Clark now brings up good points. I'm more than willing to change my mind when I feel it's appropriate.
Unless, can we just talk for a moment about her good points? The good points are these, Your Honor.
Well, Mr. Cochran, we've had the opportunity to argue it.
Well, it's just, I would just submit to the court that this is outrageous, that they would be able to come back in and reconvince, Your Honor, after we made a decision. That you're going to do this on Friday night.
Well, Ms. Clark raises.
Yo, you did this. You did this. Just you. Only you did this. You can't complain about this now.
But the possibility that if we put on Rosa Lopez now, then they're going to bring on 5 rebuttal witnesses, which is going to totally derail things.
Your Honor, they're always claiming things like that. And it turns out to be much ado about nothing.
That's what I would do if I were them.
Right. But it turns out to be much. So let them do that. I mean, they were going to be so ready to do this. Judge, they've known about this witness since last July or August.
Excuse me, Mr. Cochran, forgive me for interrupting you for just a second. Ms. Hazel, would you ask Mr. Schuman to get his gear together for me, please? Thank you.
It seems to me they've known about this witness since last summer. And the fact that we get information, Judge, in this case, this very morning, at this very, very moment, people are calling in on both sides. It's just totally disingenuous to say we got new information. We get new information minute by minute in this case, and will continue till this case goes to the jury, Your Honor. It's another stall as they did Friday night. And Your Honor has been wise and fair in this case, but certainly you can see through this. And for her to say that I'm not sensitive to child care is preposterous. What I'm sensitive to is the fact that they came in here and said, we're ready to go on Monday, but I just have to be here so I can advise Chris Darden. And now we come with this motion. And that's the thing. So I just wanted to at least have the court indicate how strongly the defense feels about this. I think that I don't want to see this court snookered by this. I mean, this stuff about a fair trial, I mean, it works both ways, Judge. They have the power of the state. They have the entire police department, DA's investigators. They've got everything. They've known about this witness since last summer. And for them to come in here now and say, we're not ready, Judge. I mean,
they're not ready. It wasn't this witness's turn. How could they be ready? How?
We hear this time and time and time again. And I just think it's unfair because the defendant's entitled to a fair trial also. And the court had made its decision. We live with that decision. And as usual, they come back and begged and moaned and asked you to do something else. And you rightfully consider those things, Judge. But it seems to me in this instance, given this record and what you said, I mean, they affect your credibility. We tell the jurors, we would have done this Friday night. You tell the jurors, we're going to take this witness out of order, come back Monday morning, we're going to do it. Ms. Lopez, who stays over, says, I'll do that for you, Judge. And you say to her, Judge, you say to her, I'll get you on, we'll testify before the jury, and it'll be over with Monday morning, and you can leave. if you want.
What she anticipated was coming here and having her testimony tape recorded, which is what we're going to do.
Well, not as of Friday night. She anticipated having it over. What they're arguing, and you know what they're doing, Judge? And let me just say this last thing, and I'll sit down. They're also
Wait, Ms. Clark.
Judge, what they're doing again is seeking to re-argue everything. They're saying, in their motion, when you rule that Rosa Lopez.
You know why he shut her up right there? You know why he didn't let her talk? She's winning. She's going to win. She doesn't need to speak right now.
Would leave to go to El Salvador, and they don't like a ruling. They try to come and circumvent it by every way they can. So what they're saying now is do this conditional exam because we know she's going to really be available, which is contrary to what you had found the circumstances. So they ask you to re-argue that particular point, Your Honor, and it just seems to me that's unfair. What happened is this case is the strings are being pulled by others that are sitting here at this table, and they come here and make a representation, and they go back and they have to talk upstairs and get their new orders, and then run down here and make these things. Ms.
Clark, please don't interrupt counsel.
And so what you're seeing, Judge, and they want to put you in the middle of their battles upstairs when one person says something, and that's not fair. And that's why you're the judge to make these rulings and make them and stick by them. So I just think we should be able to go forward as we kept. I mean, I think it affects everybody's credibility when we tell jurors something and then all of a sudden they come up with this last minute attempt. So I'm just saying to the court, you ruled. It was an appropriate ruling, given all the evidence. We should proceed with the testimony. And if they want to call 5 rebuttal witnesses, they've had all the time in the world to do that. They can call anybody they want. They were so worried about whether or not we want to call this witness. We'll make it very clear. Remember, I stood up and I invited him. I said, let's put her before the jury. You're so worried about everything. Everybody's around America is worried about Rosa Lopez. We made our decision with regard to that. It's been abundantly clear. You don't see us changing our strategy every few minutes, but where they have. And I just suggest to the court that that's not fair to the defendant when we talk about what's fundamentally fair.
Not.
And I would ask the court to.
They only changed their strategy because you are throwing a witness in the middle of their case. They have to change their strategy. She told you why. He's an idiot.
Think about that before you reverse your well thought out and well reasoned ruling.
Thank you, Mr. Guy. All right, counsel. We had not started the actual examination of the witness. What you had asked for was a 1335 conditional examination. I granted that. Since the jury was available, I decided to do that. Since then, the prosecution has brought to my attention a point that I had not contemplated. And since we had not embarked upon that course of action, it's not inappropriate for me to change that, which I'm going to do. We will take a 20-minute recess to allow the videotape equipment to be set up, and we will proceed. And Deputy McNair will need to transport the jury up to the holding lounge upstairs. Mr. Darden.
I've asked defense counsel, and I've asked on the record as well for any notes and recordings relative to any interview they had with Miss Lopez. I have not received any notes or any recordings of any interview they may have had with her, and I'd like to inquire of defense counsel if any such.
Oh, wow. That's a shocker. Discovery wasn't even done with her yet. They didn't even submit any discovery on her yet. And now they want to call her. Yep, that makes sense.
Notes or tape recordings exist.
As far as other than talk, I don't have it. We have no notes and have any recordings. I inquire with you. Only thing I can do is call Mr. Paddle. It's the only person I can call.
Well, we understand, Your Honor, that over the weekend, Mr. Schiller, who is apparently Mr. Simpson's personal biographer, spent some time with Ms. Lopez, and I'd like to inquire of Mr. Schiller if he has notes. If he interviewed Ms. Lopez, I'd like those notes, Your Honor.
Is he kidding you? That's how bad their information is, Your
Honor. If that's a denial, Your Honor.
Wait. Are you indicating, Mr. Cochran, that that's not true?
Of course, I know he didn't talk to him. He's got to talk to her.
All right.
That's fine.
All right, very good. Mr. Walsh, you had something?
Yes, Your Honor. Mr. Douglas has made an ex parte application for an order shortening time. If the court's not going to consider that now, may I be excused?
No, I'm going to consider that now.
All right, thank you.
Mr. Walsh, do you want to address that?
Yes, well, thank you, Your Honor. We received the application this morning indicating that the defense became aware on February 22nd that there may have been certain investigations into allegations against Detective Furman. They're now asking that the court issue an order shortening time till March 2nd to have a hearing on whether those documents, if they exist, should be produced and disclosed. I'm at a loss to understand why they waited until this morning to prepare these documents and file them and give them to me. It's a very short period of time for the city to analyze the request and make a determination of the stature and position that it wants to take. The only reason given in the declaration why an order of shortened time should be allowed is that they believe that Detective Furman is to take a stand on March 1st. I have no information as to whether that's true or not, but March 2nd is an inconvenient date for me for two reasons. One, I have a prior appearance that morning. Second, I have a funeral that I
And
must
you can
attend
do it on your
tomorrow, so
show,
I would have a
Fozzie.
limited amount of time to respond to the request and to determine what the city's legal position would be.
How about March 3rd?
March 3rd would be better, Your Honor.
All right, March 3rd,
Thank you. What time?
9 a.m.
Thank you.
Thank you, counsel.
All right. My blood pressure is through the roof because of that man. I mean, let me list the ways I want to smack him so hard. Everybody, don't. I'm telling you, your blood pressure will go through the roof. I don't even want to say anything because, oh man, I have so many words right now. But Marsha is not doing a bad job. He, on the other hand, and his witnesses are freaking horrible. They're just horrible. I don't understand. I mean, yes, she repeats the same question over and over again. So does he. And so do most lawyers we know. That's the only thing I see that she does. She asks the same questions over and over again, but that's exactly what they're all doing. And in a lot of the cases that I put on. I'm going to get ready to record. It's Mental Health Docket Day. I love Thursdays. Guys, thank you so much for coming out. I really, really appreciate it. Beck, I hope you're eating and resting. You know, don't go too hard. Just 1 minute at a time. I will talk to you all again very, very, very soon. I hope you guys have a great day. Bye, guys.